I'm David Branch. I'm an attorney, employment, labor attorney in Washington, D.C. Been practicing almost 35 years now, primarily representing federal employees, but we do represent private sector employees as well. But for the most part, probably 90 to 95% of our practice is representing employees. So good evening, welcome. We're just going to wait a minute to see if other folks are joining us before we get started. I hope everyone is doing well. I know that it's been a very trying period of time over the last 7 weeks, and I hope you have not given up hope. I think that there is a silver lining here, particularly with a ruling issue this week. At least the playing field, I believe, has been leveled. So it's going to give you a fair chance to fight for your jobs, and that's really all you can request here. Is treat me the same as other folks are being treated, and follow the guidelines and the regulations if you're going to take action to remove me from my position. Good evening. Just want to say hello to everyone. Okay. So let's get started here. Um, I am encouraged by some developments over the last week, particularly a decision issued by the U.S. District Court in Maryland, in Baltimore. I sent a notice earlier. You probably saw this in the news as well. Just a copy of the order. The judge basically ordered a number of federal agencies. It looks like it was maybe 15 or so executive branch agencies to return all probationary employees to work, and they have to do so by 1 p.m. tomorrow. So it's going to be interesting. I've heard from some of our clients who've already received emails from their agencies telling them that they're not returning to work, but they're going to be placed on administrative leave, basically placed back on the rolls effective tomorrow. So that's very encouraging. The problem is, are we going to get to a point where federal agencies or this administration decides that it's not going to comply with an order issued by a federal district court judge? It's very disturbing to hear some of the correspondence or communication coming out of the White House that these are lower level judges. I'd like to, see folks stand up in court and tell these federal judges that they're lower level district court judges and they have no authority to issue an order that should be followed by agencies or the executive branch. That would probably be a very scary day in court for most attorneys. I don't think you can challenge federal district court judges. These are Article 3 judges under the U.S. Constitution with lifetime appointments. So, okay, maybe have to go back to some high school civics classes to get a full understanding of how the system should work. So in the last webinar, I told you that there were two cases that we were following very closely because I think ultimately these two cases are going to impact your case. And unfortunately, one of the cases was filed by Hampton Dillinger. He was the special counsel. And so you file your complaint if you have an issue where you want to challenge agency action, particularly a violation of your rights, not following the personnel practices that should be followed, prohibited personnel practices. You file a complaint with the Office of Special Counsel, and they determine whether or not there's a valid claim, and then they can pursue it on your behalf before the MSPB. Well, the president terminated Mr. Dillinger, and Mr. Dillinger challenged his termination in court. He ultimately won a TRO and summary judgment at the district court level, but he appealed it, but the agency appealed it to the U.S. Court of Appeals for the D.C. Circuit. I was a staff attorney at that court, 30 years or so ago, but there was a panel of judges that decided that they would hear a full briefing on this issue and that they would not uphold the stay while the briefing was to be done. And a decision would have been issued sometime in April or May. So there was some concern that even if Mr. Dillinger received a favorable opinion, that decision would be appealed to the Supreme Court. There's a possibility that the Supreme Court could expand the powers of the executive in a way that would be adverse to employees. So Mr. Dillinger, he took a bullet for the team, so he decided to just withdraw his appeal. Now the only case, I think, important case that remains is the case of Kathy Harris. Kathy Harris was the chairperson, or is the chairperson at the Merit System Protection Board. Remember, the Merit System Protection Board has already determined that probationary employees should not have been terminated without following the reduction in force procedures. So there's a three-person panel at the MSPB. There's a chairperson and two other people. Two are appointed by one political party, and the other is appointed by the other political party. If you have an appeal that's filed with the MSPB, it's heard initially by an administrative judge or the equivalent of a hearing officer, and that hearing officer makes a decision. And then either party can appeal that decision to the full board, to the MSPB. It's a panel of three judges, three commissioners. If there is not a quorum, and you need at least two people for a quorum, then the board can't conduct business. So in the last Trump administration, President Trump did not appoint two people to the board, so the board could not function as it should. So as a result, for people who filed appeals at the MSPB, and if they won their case and the agency appealed, and we had clients like this, there was a period of about 6 years where these folks couldn't get a decision because the board was not transacting business, adjudicating appeals. So why this position is so important is one of the board members resigned. So there's one person on the board that's a Republican, one person on the board that's a Democrat. If there are two people on the board, that's fine. You have a quorum. If there's a case that comes up on appeal and those two people can't agree, then the decision of the hearing officer or the administrative judge, that becomes the final decision of the board. But for example, if Kathy Harris is removed and there is no quorum on the board, then the board can't hear appeals. So having her in place is really important as far as allowing these appeals to proceed. So if you're terminated and you're not provided the rights that you're afforded under the RIF procedures, if you have a full board operating at the MSPB, or if you have just two people operating, one Democrat, one Republican, and you get a favorable decision from an administrative judge, then then you will get whatever relief the administrative judge provides to you. If you don't have a full functioning board, then your case is just going to be stuck in limbo until the administration decides to place someone else on the board or there's a change of administration. So it's really important what happens to Kathy Harris's case. So Kathy Harris she was removed by President Trump. And the problem is there's a law that basically says she should not be removed, or people from this board should not be removed unless there's some type of misconduct. If there is a multi-panel board or commission and these people are appointed, Congress has said that they can't be removed unless there's some type of misconduct. Where there was no allegation of any type of misconduct, President Trump just sent her a letter or had someone send her a letter saying you're terminated, your services are no longer needed. So she filed her complaint in the district court, the U.S. District Court for D.C. That court first granted her a temporary restraining order, and then she requested judgment as a matter of law because there aren't any facts in dispute, material facts in dispute, and the court granted her judgment as a matter of law. And so now the Department of Justice, on behalf of the administration, has filed an appeal, and her case is pending on appeal. It's very likely that that appeal will be expedited as well. So if she wins this case and wins on appeal, as she should, it will likely go to the Supreme Court, and then the Supreme Court will have to make a final decision. I mean, it's pretty clear that Congress has passed a law that says this is what must be done before you remove someone in that position. And it was not done here. So there's a very good chance that she will prevail in her case. And that's good news, because if that happens, that means that the MSPB is going to be functioning as it should. The second case that's really important is this decision that was issued by Judge Bredar in the U.S. District Court for the District of Maryland. And I just mentioned that to you earlier. In that case, a temporary restraining order was issued prohibiting these 15 agencies from terminating probationary employees, and they all must be returned to work. And the judge basically says, I'm not prohibiting you from following the reduction in force procedures, but you can't make a false statement and say these people, this is actually what the judge in San Francisco said, who also issued a temporary restraining order. The judge in San Francisco said, you can't terminate these people and falsely claim that they had performance issues when you haven't made an assessment to determine if they had performance issues. And a similar holding was reached by the U.S. District Court for Maryland. The court basically said, you can't go forward with the termination of these probationary employees. You have to follow the reduction in force procedures. So I'm saying all of this to say that at least for this week's webinar, we're doing these every couple of weeks or so, the playing field has been leveled. So this takes us back to just a regular reduction in force. The agencies now have to comply with just the regular reduction in force procedures. And that's what we're going to cover here tonight. Just the reduction in force procedures, so that if you receive a notice that says that you are first, there should be a general notice of a reduction in force, and then a specific notice of a reduction in force for your position. So if you receive this specific notice of a reduction in force, we're going to cover tonight what you should be looking at when you receive it to see if, hey, this is a violation of the regulations or maybe a violation of my rights. Okay, so now let's take a quick look at this. Let's see, tonight we're going to talk about the reduction in force. I want to do a quick review just generally of the requirements for terminating federal employees. I covered some of this at the last webinar. I want to just review it tonight, and then we're going to go directly into the reduction in force. So I mentioned previously that probationary employees. Of course, we have folks who are serving a 1-year period of probation. Some people are serving a 2-year period of probation. There are some people who are Schedule A employees who have to serve a 2-year period of, well, I'd say all Schedule A employees have to serve a 2-year period of probation. So, but there are different categories. It's not just a permanent career employee. You also have accepted service employees. There are different rules that apply to them. You have people who are conditional employees. Then you have people who are AD employees or administratively determined employees, which is kind of almost like an at-will employee. So there are all these different categories. Some of these people can appeal their removals to the MSPB. Others, the MSPB doesn't have jurisdiction. So you're going to have to talk to counsel or get some advice on where you should challenge your termination if you receive a termination notice or reduction in force notice and you can't file with the MSPB. We've had clients over the last month, including people who worked in DEIA or DEI offices, and their whole office was either placed on administrative leave. We have some folks who are still on administrative leave, have been there since January 22nd. Others, their agencies have terminated them. Under normal circumstances, there's a process that's followed when you have a reduction in force. It takes months and months to plan a reduction in force because there are so many rules and regulations regarding a reduction in force. The agency has to comply with all of these regulations and rules, and if it fails to do so, then you can challenge that decision. Usually you can do it by yourself or get counsel, challenge that decision at the MSPB, and if you prove that the agency has failed to comply with the regulations, then the MSPB is going to order the agency, determine that the termination is invalid and order the agency to return to work. So that's why I'm saying don't give up hope. Even if you get a specific notice of a reduction in force, that's not the end of it. It may be that your employment is going to end, but once you challenge this and if you win and the MSPB is functioning as it should, there's a very good chance that you will be returned to work. We've had many employees, many clients who were received a reduction in force notice. The agency failed to do something that it should have done, and there was a determination made that the employee should be returned to work. So even if you go through this reduction in force, there's a possibility that you could be returned to work. What we're doing is we're working with clients. We're actually going to bring on just someone, a subject matter expert in the RIF policies, just to work with our attorneys to make sure that we go through the reduction, all the notices that we receive and requests from clients to review their reductions in force. We're going to go through them and make sure that they comply with the regulations and then advise the client. Look, there's a chance that you could prevail. There's a possibility that a very good chance that you could prevail, or we're going to say, look, the agency's done everything that is required to do, and you're going to just have to go through this reduction in force and accept what's being offered. But there's so many boxes that the agencies have to check to complete these reductions in force. Now, President Jimmy Carter is probably smiling in heaven because this is all because of action that he took in 1979 as part of this Civil Service Reform Act. That there be a fair process in place to evaluate whether people are being RIFed or furloughed or being terminated. And so this process involves just a number of different steps. So tonight we're going to work through first. I just want to talk very quickly about terminating federal employees. So I'm going to ask Kaylin to pull up the exhibit or the handout, and I just want to walk through this quickly. We covered some of this at the last webinar, so I'm just going to move through this pretty quickly, just the first page of the requirements. Since the courts have determined, here we are, the courts have already determined that for probationary employees, you cannot provide a false reason. That's the first point here. For probationary employees, cannot provide a false reason for the termination. That was an issue that the judge in San Francisco that really, I think, made him pretty upset. The fact that these agencies, the US government, was telling folks who were probationary employees who had satisfactory or meeting the expectations of their position, had good evaluations, and the US government was telling these folks that we're terminating you because you're not a good fit for the agency, or your knowledge or your skills or abilities are not a good fit, and based on your performance, we're terminating you. Which the judge has said that was just a flat out lie. And the judge there, as well as in the district court in Maryland, basically said that this termination of probationary employees is really just a mask to cover a reduction in force. And if you're going to do a reduction in force, follow the policies for the reduction in force. At the MSPB, you cannot terminate a probationary employee. There's a specific regulation that says you can't terminate a probationary employee for political reasons. That has been interpreted as being affiliated with a political party or for your marital status. And that may be something just from the, I don't know, 70s or earlier, but I don't see how marital status matters. But in any event, probationary employees can't just be summarily terminated. There has to be a reason for the termination. And this is what we're going to get into tonight. The reduction in force. We're going to take a look at a reduction in force, specific reduction in force memorandum tonight. For a reduction in force, so if you're facing a reduction in force, the agency has to give you 60 days notice. So today is March 16th. So the earliest, if you got the notice today, the earliest that it could be effective would be whatever, May 15th or so, 60 days from now. but the agency must do a number of things. There's a lot of planning that's required for a reduction in force. There needs to be a competitive area, and we're going to look at the definitions tonight of what a competitive area is. There must be competitive levels of all the folks who will be impacted by the reduction in force. And then they list all of the employees on a retention register. They will also have to note your performance. And then they will offer RIF employees uh, assignment or reassignment and priority placement for vacant positions. And then if that's not available, you should be offered severance based on your years of service. Now, if you are offered a position, if you're identified as someone who's going to be subject to a reduction in force and you're offered a position and you decline that position, the agency no longer has an obligation to provide severance to you. But of course, with this administration, the goal is to reduce the number of federal employees. So in my opinion, I haven't seen this happen yet, but I think it's going to be very unlikely that your agency is going to offer you another position. I mean, a lot of folks um, who suspect they're going to be terminated or as part of a reduction in force or receive notice have attempted to move into other positions or go on details, and the agencies have resisted that, at least the agencies that we've seen so far. All right, so when we covered this earlier, filing a legal claim for probationary employees. If you're going to file a complaint challenging your termination as a probationary employee as a prohibited personnel practice, you file that with the Office of Special Counsel. Remember, as I said earlier, the Office of Special Counsel has a number of attorneys working in their office. I don't know if they're associate or assistant attorneys, but a number of attorneys working in the office. But the office, the person who heads the Office of the Special Counsel, has been removed from his position. So if I'm advising a client, I would say don't go to the Office of Special Counsel at this point, because there's a possibility that I'm not sure what's going to happen to your case at the end of the day, whether they're going to pursue it at the MSPB. If you ask me whether they're going to challenge an action by an agency removing an agency employee, even though this office should act independently, I would probably conclude that there's a good chance that that's not going to happen, at least not as aggressively as the prior special counsel. The other option is to file with the MSPB, Merit Systems Protection Board. There's a form that's filed. It's a notice pleading form that's completed. We help clients do that. And then I'm just generally saying the arguments that you would make that the agency has carried out a reduction in force without following the RIF regulations. You can request a stay of the termination, reinstatement, back pay, and attorney's fees. Let's scroll down, please. And if you are a permanent career employee, just very quickly, um, if you're a permanent career employee, you have a property interest in your employment and you cannot be deprived of that property interest without due process. And what does that mean? You can't lose your job, or the government can't take your job based on your performance or based on conduct without providing due process. And employees must be given notice of any performance or conduct issues and given an opportunity to submit a written and oral response. We just did that for a client this week who worked for one of the agencies, and her job required her to work on election interference for the 2020 election. And this administration took the position that anyone who worked on election interference in 2020 um, had somehow violated the First Amendment right to free speech of Americans, and all of the people who work within this particular department were terminated. So as a result of that, we had to submit a written response on behalf of our client, raising all the issues there, as well as submit an oral response. We actually met with the deciding official. There were a number of issues in that particular case. One of the issues was this person worked on this assignment back in 2022. So it was almost 30 months ago that she actually worked on the assignment, and she only had this assignment for I think a period of 5 months, but did maybe less than 10 hours of work on this assignment, and she was doing primarily administrative work. So we raised all types of issues related to this effort to remove her because she worked on this assignment. I think that probably violated her own First Amendment rights by doing that, but there was no documentation of anything that she had done wrong. So the agency just can't remove you for performance or for conduct, and in that particular case, it was a case of conduct, if there's no valid reason for doing so. All right, so for termination based on performance, just very quickly, the agency can't mask it as a reduction in force. The agency must provide notice and an opportunity to submit a written and oral response. And the agency must show that the employee had poor performance before placing the employee on a performance improvement plan, and then the employee still fails while on the performance improvement plan, and then the agency can move forward with termination. So for most of you, I think it's very unlikely that your agency is going to remove you for a performance issue, at least unless there was already some other performance issue. But the agency is planning on reducing its workforce significantly. And here's the issue. I think, I'm a firm believer that if their motives are not good, if you give them an opportunity, they're going to make a mistake and try to do something to harm you. So we have some clients who don't have the best relationships with their supervisors. And if the supervisor sees an opportunity to get rid of this person, or get rid of you as an employee, they're probably going to put your name forward for folks to be considered as part of the reduction in force. Now, if they want to do that, that's fine, but the agency is going to have to justify why your name is on the reduction in force list. And I'm going to go through some of the things that I think you can raise if that becomes the case. If you find yourself in a position where your supervisor places your name on this list of people to be impacted by the reduction in force. We're going to talk about that in a minute. The next issue is conduct. I just touched on that a minute ago. If there's an allegation that your conduct warrants termination, and this is true for some folks who've worked in DEIA or have maybe worked on election security issues, the agency's trying to advance the narrative that they are being terminated because of their work on DEIA and or work on election security issues. So a number of issues that we can raise to challenge that. And I mentioned a couple of those just if the action was taken some time ago. And then there's a whole series of factors that have to be considered if your agency is contemplating removing you for conduct. They have to consider the leading case is Douglas v. Veterans Affairs, and we call this case the Douglas factors, or the factors that come out of that case we call the Douglas factors. So there's 12 factors the agency must consider before making a decision to terminate you based on conduct. And if it fails to do so, this is a violation of your due process rights and you can challenge it. All right, so next is legal challenges for termination of career employees. You can file with the Office of Special Counsel. You can file with the MSPB. Let's go to the next page, Caitlin, please. So as I mentioned previously, there are different types of employees: probationary employees, different categories of employees, career, permanent employees, conditional employees, accepted service employees, administratively determined employees. So here are some of the possible challenges. For career service employees, challenging a reduction in force, the courts are clear. You have to file with the MSPB, the Merit System Protection Board. If you fall within one of the other categories and the MSPB doesn't have jurisdiction over your claim, we dealt with this with a client this week. He worked for I think it's Health and Human Services. He is a conditional employee. Fortunately, he was a probationary employee, so he's going to be returned to work tomorrow anyway. But if you are a either probationary employee or a conditional employee and a permanent employee, well, conditional beyond your probationary period, let me just say that. then you're not going to be able to file with the MSPB. You're going to have to look at possibly constitutional claims. And so if the MSPB doesn't have jurisdiction, the courts have said that you first have to go to the MSPB if the MSPB has jurisdiction. But if the MSPB does not have jurisdiction, you do have the right to challenge your termination in court. And you can challenge it under the Administrative Procedure Act as the agency taking action that's arbitrary and capricious. Under the First Amendment, if the agency has taken this action against you because of your expressing speech or association, being associated with a program that's fallen out of favor or is disfavored by the administration. The third option is a possible violation of your Fifth Amendment rights. You have the right to life, liberty, and property under the Fifth Amendment. And also under the Fifth Amendment, you can assert a claim against the federal government for a violation of your equal protection under the law. So you have the right to equal protection under the law under the Fifth Amendment. Okay, so now let's turn to the reduction in force. All right, so if we can go to the next page. Okay, so let's actually go to page 5, Caitlin. I want to cover this very quickly. Let's go to the next page, please. Great, thank you. Under this section, are you there? Okay, great. Okay, if you can make that a little bigger, just the content. Okay, as I mentioned earlier, if your agency decides to separate you through a reduction in force, that's going to be probably the most prevalent type of action taken over the next 30 days here, maybe starting as early as this week. We saw one of our clients receive a specific reduction in force this week, just this past week. The agency has to issue, it typically has to issue just a general reduction in force, just announcing to you or providing notice that it's going to do a reduction in force. And then the Code of Federal Regulations provides that it must provide you with a specific notice of reduction in force. And here's the content. Generally, what needs to be included in this specific notice of content, the agency has to identify the action to be taken, the reasons for the action, and its effective date. Once again, it needs to be 60 days out. The effective date needs to be 60 days out from when you receive the notice. So if you receive the notice this week, there's a possibility that some of you will receive the notice. Remember, the administration gave a deadline of last Thursday, I think, March 13th, for the agencies to come forward with a reduction in force plan. Basically tell the administration how they intended to reduce their federal employees. Some of the agencies, I think the GSA, may have orders or directives to reduce their workforce by as many as 50 to 60%. We saw at the Department of Education, 1,300 employees were either placed on administrative leave or received notice that they were going to be removed from employment just this past week. Thousands more across other agencies. So it's the goal of this administration to reduce the federal workforce by, it looks like, at least 30% or more. So we have 2.3 million federal employees. So it very well may be that we're going to see, up to 500,000 people lose their job as part of a reduction in force. Remember, they can't really do this as a performance issue because of all the steps they have to follow to show that your performance is not meeting the expectations. They have to place you on a PIP and give you a period of time to perform on the PIP, and then if you fail to perform on the PIP, then go forward with the termination. So that could take months. If there's conduct, there has to be some conduct that they have provided you notice of, and you violated whatever regulations or policies from your agency, and then they have to follow the Douglas factors as well. So that's unlikely unless you have engaged in some type of misconduct. So the only option that's going to be available at the only viable option, I think, that's going to be available at the agency now is to try to make the case to reduce the workforce through a reduction in force. So if they're going to do this, they have to list your competitive area. And we're going to talk about that in a minute, the competitive level, a subgroup, service date, and list your three most recent performance ratings. All right. And then they have to um, let's see, I'm just going to read this. The place where the employee, they have to inform you the place where you can inspect the regulations and the records relevant to your case, the reasons that they are retaining a lower standing employee in the same competitive level, and information on reemployment rights. As you can see, this is a lot that the agency has to do before it goes forward. They have to advise you of your right to appeal to the MSPB. And I'm just looking at this 6B, when an agency issues employee a notice, um, the agency must, upon the employee's request, provide a copy of the OPM retention regulations. That's what we're covering tonight. This is part 351. Now, let's go back to the page number 4. Okay, and so this is just to define a competitive area. Each agency shall establish competitive areas in which employees compete for retention under this part. So your agency has an obligation to establish a competitive area. And so we're going to take a look at a specific notice in a minute, but for you, the way that you can protect yourself as an employee, you want to, you know what your title is, you know what your series is, you know what your grade is. You want to identify or try to get the names of other employees, hopefully it's employees with less seniority than you, who have the same title, the same grade and same series. And you need to determine if those folks are going to be subjected to the reduction in force. If not, you're going to try to make the case that, hey, you're required to list all of the employees in a competitive area. And basically from there, it's just seniority and your performance evaluation. So if you have more seniority and you have favorable performance evaluations, you should not be subjected to this RIF before this other employee, even though maybe your manager favors this other employee. So that's one of the things you want to do is think about who else is working in the same series, has the same title, and is roughly at the same grade. One of the things that you may want to also consider doing is trying to get your hands on prior reductions in force, because I've seen now, and we're going to see this tonight in a minute, agencies are going to try to maybe limit your competitive area to just those people in your office or people within your particular unit. So if you can somehow show that in prior reductions in force, maybe that impacted my office or other offices, the reach of the competitive area was much more extensive than it is now. All right, so that's one point. The next point is a competitive area must be defined solely in terms of the agency's organizational unit and geographical location, except as provided. This should be paragraph E of this section. Now, I was just thinking about this. Um, Many of you are working remotely. So what does that mean for a geographical location? This particular part of this regulation may just be outdated because since COVID, many people haven't been back to the office in Washington, D.C. We have some clients who work in Ohio, work in Alabama, work in California. And so, what is this geographical location? How can you have a competitive area of Washington, D.C. when you have all these people working all over the United States. So that's going to be a problem defining the the competitive area if you just limit it to Washington, D.C., when many people haven't, they were hired under a 100% remote work or telework agreement, and they haven't worked in Washington, D.C. So these are going to be ways that we're going to challenge any effort to limit the competitive area to just Washington, D.C. And so we want to expand this so that there's someone on the list with less seniority that you would have the right to bump that person, and that person would be terminated and not you terminated. But that's something that we would do. We're going to do with our clients with a someone who's an expert in the area of reductions in force. All right, so that's one part. And then let's just scroll down. The next point is C, when a competitive area will be in effect less than 90 days prior to the effective date of a reduction in force, a description of the competitive area must be submitted to OPM for approval in advance of the reduction in force. Now, I'm not sure how agencies are going to deal with this. If there's a requirement that they submit a competitive area to OPM for approval, if this competitive area is less than, has been in effect for less than 90 days. So the agency is going to have to prove all of these points if you challenge this decision at the MSPB that this competitive area was in effect for more than 90 days, or if it was in effect less than 90 days, they're going to have to prove that they actually went to OPM and got approval. I doubt very seriously that they've done that. So that's going to be another way to challenge this. Let's scroll down to the next page. Competitive level. This is another important point. OPM regulations, this is just a summary. OPM regulations provide that agencies shall establish competitive levels consisting of all positions in a competitive area, which are at the same same grade or occupational level, classification series, which are similar enough in duties, qualification requirements, pay schedules, working conditions, so that the agency may reassign the incumbent to one position. Reassign the incumbent of one position to any of the other positions in the level without undue interruption. So if you're identified as someone who's going to receive this specific reduction in force, what do you want to do? You want to make sure that the competitive level includes someone with less seniority, so that instead of your position being abolished and you losing your employment, unfortunately, that the person with less seniority will lose their position. So we've seen many cases before the MSPB where agencies came before the where agencies terminated employees, and employees raised that argument. Your competitive level was not correct. It should have included someone else. And the agency usually responds to that by saying, well, it was correct not to include that person. Maybe that person didn't have the same duties or was not a supervisor. And that's why I said one of the things that you want to do is identify people who have the same series, the same title, and perform essentially the same duties. We had this issue with one of our clients at the VA. They worked in one particular division or department that performed duties very similar to another department. Well, my client has received a specific reduction in force. People who perform the same duties in this sister or companion department did not receive the specific reduction in force. So I think we have a very compelling case to show that the competitive level is not correct. And what's going to happen is going to be an examination of your position description and the position description of the position that you are competing against, or that you want to be included. So if you have access to your position description or access to this other position description, make sure you keep those records so that you can have that as evidence in your case. The other important point may be to keep organizational charts. One of that, you're going to see this over and over again, that the competitive area needs to take into consideration this organizational unit. So if you have organizational charts, many times agencies will do this and say, here are the reporting relationships, who's at the the agency head or the head of your division, and then it lists all the positions. And if you can somehow get access to these organizational charts, that may be critical evidence in showing that your organizational unit is the same as this other person that you're comparing yourself to, and this person should not have been retained and have you placed on this list of folks who are subjected to the specific reduction in force. All right, so now let's scroll down. I want to take a quick look at a sample specific reduction in force. Let's go down to the next page, Caitlin. When you receive okay, here we are. We redacted, this is an actual client, so we redacted some of this information. They just received this last week. You should get something similar to this. This is a specific reduction in force. And it just says, we regret to inform you, you've been identified for separation by a reduction in force. Remember all of the policies that we just covered a few minutes ago. This notice should include all of that information. So it should tell them that they are being subjected to a reduction in force, the effective date of the reduction in force, and why you're being subjected to the reduction in force. This just says that we've taken necessary steps to ensure the integrity and validity of this action. Don't believe that. And you will be separated from federal service effective, this says May 10th, 2025, which is roughly 60 days from March 11th. This person was being separated because there was a determination made that they worked in a DEIA office. So that's an issue that's still going to be litigated. But they're saying is pursuant to this Executive Order 14151. And it says that we're closing your office and conducting a reduction in force. This constitutes a specific reduction in force. So you should receive something similar to this. If you get this, call our office. No, don't call our office, but if you want us to review this and go through this with you, send us an email and we'll schedule some time for a consultation if you want to do that. All right, so this should identify your position. We've redacted some information, but your title. So what are you doing? You're looking at other people here who hold the title of management and program analyst, whatever the series is, whatever your grade is. For accountants, maybe it's 510 or whatever your series is. And then this competitive area, here it says RIF organization limits that employees compete for retention. Not sure why that's included here. And then it says per OPM memorandum dated January 24th, 2025. This is an issue because there is legal authority now. One of the judges has said that the OPM has no authority to take any personnel actions. All right, and then this says the DEIA office where employee worked. Now, remember, I said this once before, that for this competitive area, it needs to be, there's a geographical component to it. You just get the language here. This competitive area should include the organizational unit and geographical location. So there's going to be a problem here, including limiting this competitive area to the DEIA office where this employee worked, because although the office may be based in Washington, D.C., this employee could be one of the remote employees who worked anywhere in the country. So how does that impact this decision if the regulation says it should be limited to the geographical area? Remember, there was a time, maybe many years ago, when everyone had to come to the office in Washington, D.C. And so if you're doing a reduction in force, you're not going to include people who work in New York or Dallas or Chicago or LA in this reduction in force when the focus is on this geographical area of Washington, D.C. That's not the case anymore, since people work all over the country. Many people were hired into positions that are 100% remote. So that's going to be a problem. I think that's going to help us prevail if we have to challenge this. And then there's the competitive level. Once again, and I'll just look at the regulations for the competitive level. It needs to consist of all positions in a competitive area, which are the same grade, classification series, and similar enough in the duties, qualification requirements, and working conditions that the agency may reassign the incumbent to one position and of the other positions at the level without interruption. And here this just says all positions within the Office of Equity Assurance. That's the position, but they haven't looked at other offices. And so there may be a case to be made that there are other offices where people perform the same duties and should have been included in this competitive level. All right, so we're just going to scroll through this. This also just lists that you're a career employee. It gives your service date, and then it will list your performance ratings for the last 3 years. Another factor to be considered is veterans preference. I don't see this on this form, but the agency also has to take into consideration whether you have a veterans preference before including your name on the list of people to be subjected to this reduction in force. So there's a lot that's required to generate. This is just guidelines of where you can go to appeal the decision or get the regulations that are applicable. So that would be included in your specific reduction in force as well. But as I said at the beginning, it takes some time to properly prepare a reduction in force. And most agencies, it takes first, it's initiated for the right reasons, and that's going to be a problem with federal agencies terminating people through the reductions in force. One, because the motives aren't right. We know that the motive is not because people aren't being efficient or aren't doing their job. It's basically fulfilling a campaign promise to reduce the workforce by a certain number of employees. And the people who've decided that they're going to just do this with a hammer or with a chainsaw, instead of doing this like the way that normal reductions in force are done, where your agency determines that instead of 5 IT specialists, we only need 2 IT specialists to do the job. So 3 people are going to lose their job, or this job that you're performing is going away completely, and we no longer need you to perform that job. There are valid reasons for conducting a reduction in force. We will have to see how these agencies and this administration makes the case that these reductions in force, one, are valid, and two, comply with the law. I see a lot of issues so far. So I'm going to take just a couple of questions, but what should you do if you receive this reduction in force? I mean, I think you really have 3 choices here. You can basically accept it and decide, hey, I've had enough. I'm going to move on. I don't really need the stress, the headache. I don't want to, deal with this anymore. For those of you, that may be fine for some of you. And some of those folks have already decided to just take the deferred resignation offer, or you already had plans to retire, so it really doesn't matter. But for the vast majority of federal employees, you have 10 years or 15 or 20 or 25 years of service. You have a mortgage, you have kids in college. You really don't have the option of just kind of walking away from this if there's any possibility of getting your job back or continuing to receive your salary as long as possible. And we've had the good fortune of representing a number of people with disabilities. We're involved in litigation now with people who are deaf or hard of hearing. And I do apologize tonight, we didn't get our sign language interpreter on. We usually try to make that a priority because we've represented a lot of folks. But these people are terrified of losing their jobs. They don't want to have to go back out into the job market, and they're 40, 45, 50, 55 or 60 years old, maybe with some type of disability, and try to find another position. It's very difficult to get federal employment and to just lose your job like this. My suggestion to you is if you suspect that there's anything improper or untoward about your separation, to reach out to counsel and at least schedule a consultation or confer with counsel or someone else. You don't have to do it with our office, but reach out to someone and have them review your specific notice of reduction in force and review the regulations that the agency is required to comply with. And then make a determination whether you're going to challenge that. If you're going to challenge it, you can challenge it at the MSPB. Someone said, if you're subjected to a reduction in force, can you be rehired? The answer is yes, you can be rehired. It's not based on performance, not based on conduct. But if you have to think about this, if the agencies are reducing their workforces by 10 to 20 to 30%, what is the realistic possibility that your agency is going to be rehiring you anytime soon, or rehiring people anytime soon? Right now, these agencies have to justify why they have to justify their head count, and they have to bring in a report of how many people they're actually eliminating due to a reduction in force. All right, so Caitlin, I'll just let me know if there are any questions that we can answer in the next, I guess, 3 to 5 minutes.
When a whole office has received a reduction in force, are folks often filing a class action lawsuit?
Okay, so if the whole office has received a reduction in force notice, you have the option of filing uh, at the MSPB. And it's not really clear at the MSPB whether one person can be a representative or each person has to file. Just to be on the safe side, I would probably encourage everyone to file. A judge can always bring all the cases together if they're the same case, and they will likely do that anyway if it's the same case. Normally, for a class action, there needs to be anywhere from 30 to 40 people who are impacted. So probably not a class action, but you could probably have the equivalent of a collective action, or just kind of a group action that's challenging the same action by the agency. So yes, you can come together and join and see it heard, and that's really more efficient um, for a judge, instead of an agency, instead of the MSPB having 25 individual claims that are basically the same, where the agency's defense is going to be the same. It definitely makes more sense from a standpoint of judicial economy to have all the claims heard at once.
Does pursuing my RIF via MSPB versus seeking legal counsel to represent give me any more leverage?
Um, Well, I'd like to think that having counsel helps or gives you an advantage, but you definitely have the right to pursue your claim at the MSPB without counsel. You definitely need to get someone to help you understand fully the reduction in force policies and how the MSPB has interpreted the reduction in force policies. But this is something that you can do this on your own if you have the time, and if you are, inclined from a standpoint of understanding legally how the process works and what these decisions issued by the MSPB actually mean. But you probably would be well served to at least get counsel involved to assist you.
If you are offered a RIF, is the government responsible for providing career assistance for another position?
The government should give you, or your agency should give you, the specific guidelines on what is obligated to do as part of the reduction in force. I think that there's at least a provision in the specific notice that we just looked at where there's some type of assistance that's provided. I haven't really explored that in detail, but that should be included in the specific notice, the exactly what the government is required to do. And as I mentioned to you before, if you are offered another position, you decline the position, that may end the government's obligation to pay severance. But if not, then OPM has guidelines on the type of severance that you will receive. It's usually a number of 1 or 2 weeks for each year of employment up to 10 years, and then 1 or 2 weeks for every year after 10 years. And we had this question earlier this week. Someone was trying to decide, should I take this deferred? They still had the option of taking the deferred resignation offer, which would end, I guess, September 30th, or go back to work and face the possibility of getting a specific reduction in force, which would extend their employment by 60 days and get some type of severance. And when we ran um, the numbers, it really wasn't that much of a difference since now this is already March. So let's see, April, May, June, July, August. So that's 6 months. If you take the deferred resignation, it may have been like 5 months if they were actually selected for a specific reduction in force and the agency did everything that it was required to do to move them out. So it really wasn't a big choice. And the person decided, I'll just take my chances going back to the agency because there's a chance that I won't get a specific reduction in force or it could be delayed. But if I take this deferred resignation offer, I'm definitely out by September. Okay. One final question and we're going to wrap up for the evening.
Does filing an MSPB action or other lawsuit put your severance pay at risk?
No, the agency has an obligation to um, follow the reduction in force guidelines. So that doesn't put your severance pay at risk. Whatever you're entitled to receive as part of the severance pay, you will receive it. Now, if you say, for example, you won't be able to challenge the reduction in force until it becomes effective. So if it becomes effective in 60 days, that's when you file your appeal with the MSPB. In all likelihood that you will receive any severance pay, well, after the 60 days, but maybe within the next month after the 60 days. Your case will likely still be at the MSPB in 60 to 90. Well, definitely within 90 days, it'll still be at the MSPB unless the agency just walks in and says, we were wrong, we're going to reverse this. And so if that happens, then you're going to be put back into your place of employment and you won't get the severance pay. Okay. All right. So that's it for this evening. Thank you all for joining us. Always, you can reach out to us. We are um, scheduling half-hour consultations. If you want to schedule a half-hour in-person Zoom consultation, just reach out to us. If you would like for us to get involved and represent you in your MSPB appeal, either through a reduction in force or some other employment action, just reach out to us as well, and we will get you scheduled for a consultation. Okay, everyone have a good evening, and we will see you soon. Thank you.